And I think the piece that people don't understand is that the bar can only regulate those that we regulate. We don't have a police force. We can't go out there and just shut down people or tell people what to do. We only have authority over those that we regulate. So the best way that we can protect the public and ensure the health of our profession is to bring folks into the sphere of regulation. And there we can put in safeguards, we can monitor it, and we can discipline if necessary.
Today on LawNext, on December 5th, the Supreme Court of the state of Washington issued a historic order authorizing a regulatory reform pilot program by which entities not owned by lawyers will be able to deliver legal services. This makes Washington only the third state after Utah and Arizona to approve a comprehensive change to the longstanding rule that only entities owned by lawyers can practice law. My guests today are from two of the organizations that proposed this pilot to the court and that will now be tasked with partnering to get it up and running. They are Tara Nevitt, the executive director of the Washington State Bar Association, and Craig Schenk, a member of the Washington Supreme Court's Practice of Law Board. As for me, I'm Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to today's guests, please take a moment to hear from the sponsors who so generously support this podcast. You didn't go to law school to waste time writing and responding to discovery requests. Never waste time on discovery again with BriefPoint. BriefPoint drafts your discovery responses and requests for documents within minutes of your first sign-in. BriefPoint is the most reliable discovery drafting solution on the market, and it works right out of the box. Get your first document drafted by going to briefpoint.ai and clicking Get Started. No credit card required. BriefPoint. Draft what matters, automate the rest. Tired of software that doesn't speak your legal language? Case is the cloud-based legal practice management system that understands the unique challenges of workers' compensation, employment law, and insurance defense practices. Case helps your firm automate document workflows, track time with precision, and reconcile payments effortlessly. Stop wrestling with generic tools and start scaling your practice. Discover a practice management solution designed for you at meruscase.com. That's MERUS case.com. Now let's get to today's conversation. Well, Tara and Craig, thanks for joining me today, and especially for joining me in the middle of the holiday season, or at least the start of the holiday season. I know it's a busy time for everybody, so I particularly appreciate your doing that. Before we get into any of this discussion, I thought it would just be kind of useful to have each of you tell us a little bit more about who you are and what you do. So, Tara, you want to kick us off with that?
Sure. And thanks so much for having us to talk about this. It's a big deal for us, and we're excited to be embarking on this. So I have been at the Bar Association for going almost 11 years now. I originally came to the bar to work with our State Access to Justice Commission, and my background is in civil legal aid. I started my career as an immigration attorney working for Catholic Community Services here in Washington. And I became the executive director about a little over 5 years ago.
Following up on that, the fact that you came out of that access to justice and legal aid background, this must particularly kind of hit home for you, this development.
Absolutely. One of the reasons I wanted to come to the Bar Association is, at first glance, it may not seem like the place where all the action is happening. It's kind of a stodgy institution, or at least I think that's how people think about it. But I saw that the Bar Association has a critical role to play in what our profession looks like and how it serves the public. And it felt like I could have an impact here. So yeah, starting with the Access to Justice Board and then getting the opportunity to serve in this role where I can really help chart the direction that we're going, it's really exciting.
Great. And Craig, how about you?
Thanks, Bob. It's great to have a chance to talk with you.
Likewise.
So I am I run a small consulting practice, solo practitioner at both legal and some other business consulting. My path to get to this went by way of big law. I was a partner at Perkins Coie for many years, and then big tech. I went from a couple of small tech companies over to Microsoft, and at Microsoft then had a chance to do both some engineering management and quite a bit of different work across legal and corporate affairs in a fascinatingly dynamic, diverse, and creative environment. So I've had a chance to sort of explore the entire range of practice areas, and I'm now a solo practitioner.
And since we heard from Tara on this, I'm curious, what's your kind of interest in the whole access to justice issue?
So this was sparked in many ways by the experience at Microsoft. Well, how does big tech become an access to justice conversation? There are two different parts of that. One is, of course, the recognition that we have a responsibility that is larger than ourselves. But as much as that was also the learning as I went through my time at Microsoft that there is a tremendous amount that we can accomplish to make the practice of law more efficient, more effective, and serve our stakeholders better. And interestingly, a whole lot of that is available to large corporations because they can practice in these coherent, cohesive units that include engineers, that include the kinds of social science participants that are necessary, and include lawyers in ways that are not permissible in the practice of law because you can't create integrated units of all of those players in a single service. And so that I started to develop a recognition that we could do a lot more for the citizens of Washington if we could unlock some of that capability.
So, as we're sitting here today, a couple of weeks ago, the Supreme Court, the Washington Supreme Court, entered this order approving this entity regulation pilot. There's a lot I want to drill into and talk about here, and I realize we're just at the point where the pilot has been authorized by the court, and now the, I guess, hard work starts of getting it set up and running. But could one of you kind of sum up for us what the court did here?
Tara, do you want to go ahead? Or
Sure.
correct me either way.
What the court has authorized is for us to do a time bound, data driven test of entity regulation. And so, what that looks like is that they have authorized us to solicit applications, proposals from different organizations that would like to experiment with the way that we deliver legal services. That proposal has to include which ethical rules are getting in the way of the way that they want to deliver legal services. And primarily, we think it's around lawyer ownership of law firms. They also have to explain how this will improve access to legal services. And they also have to help us figure out what data can we collect to ensure that there is no harm to the public. Once we look at those proposals, we will figure out which ones we would like to test. And then we will go back to the court, and the court will have to authorize each particular instance that we would like to test. And then we're off to the races. Then we're gathering data, we're, reviewing the data, we're in constant communication with both the participants in the test as well as the court whom we'll be reporting to on a quarterly basis. And, the hope is that by the end of the pilot, and the court has given us 10 years from the point that we admit the first participant, the hope is that by the end of the pilot, we will have enough data to decide, how do we want to move forward? Do we want to continue with this model that we've created for testing? Do we want to permanently change some rules? Or do we want to get out of it altogether and say, this isn't working, there's too much risk?
When you say this is a time-bound pilot, are you talking about the 10-year expiration date, or you're also talking about the duration of the licensing of the specific entities?
It's both. So we have 10 years overall, and the court order indicates that each entity will be we get to decide how much time we want to ask to collect data. So we have some flexibility there, but the court has put an upper limit of 7 years on that. Now, the court could always tell us it, and we could always recommend, you know what, we're going to need more time than this. But the idea is that, yeah, it's 7 years of data collection, no more than, and 10 years of the test itself.
Craig, I know the Practice of Law Board was instrumental in bringing this to the court. What's the genesis of this proposal in the first place? How did it end up coming before the court?
I might even go back to the pre-Genesis period, and that is the Practice of Law Board a little over a decade ago had added to its mandate the task of the obligation to consider and recommend to the Supreme Court new avenues for persons not authorized to practice law to provide legal and law-related services that might otherwise constitute practice of law, with the explicit intent that that would help with access to justice issues. It's been in the Practice of Law Board's mandate to consider and propose these ideas. And that has then taken sort of a long process of evaluating what may work, what may be palatable, what actually can be adopted. Along came Utah, and frankly, they did the hardest job of all. They were first, and in being first, they helped to pave the way. They helped to essentially socialize an idea for us, but they also helped to identify some of the real problem areas. And frankly, they identified some areas that, to our Supreme Court, were things that they wanted to emphasize differently. And so our Supreme Court focused very much on the access to justice attributes. The Utah Project has since then increased their focus on access to justice. But our Supreme Court really wanted an access to justice part of the evaluation of each of these. And for us, access to justice really means access to legal services. We're not going to try to solve the entirety of the access to justice crisis all at once, but we do want to make sure that we are improving access to legal services. So that was the genesis and frankly, the starting point. But along the way, we got a lot of feedback, including from the court and from the bar, that did quite a bit to change the approach to the system.
You did get a lot of feedback. I know you had put this out for, I guess, public comment or comment from the bar. I mean, what was the response that you got when you put this proposal out for comment?
Well, first we were thrilled. We got almost 50 detailed written comments that came in. Some of which were individual public member, some individual lawyer comments, some that came from entities that commented broadly. These comments were incredibly valuable. So I'd start with a call out that says just a huge thank you to everybody who provided that feedback. Even those that were directly opposed to the project gave us some input or insight that we were able to fold in. And there were several comments that were specifically folded into the final order. The comments ran about 2-to-1 in favor of the project and contained some very deep, very thoughtful comments from academia and civil society on how we might think about this, as well as from practitioners.
Tara, I know that a lot of 2-to-1 in favor of the proposal. There's still a lot of your members who are probably not thrilled about this proposal. I mean, certainly that's been the case all across the country as these kinds of proposals have been floated and talked about. Have you had conversations with some of those members, and what do you say to them about this?
Yeah, I certainly have. And I understand the concern. It's a hard time for consumers of legal services. It's a hard time for legal professionals as well. It's not easy for anybody out there. And everybody is concerned about, how's this going to affect their ability to earn a living? And also, they're concerned about how it's going to impact the public. What I hear mostly from legal professionals is, I have seen people who have been harmed by online legal services companies or by folks who aren't authorized to practice law. They provide a service, it's not high quality, they cause problems, then I'm asked to come in and clean it up. I think my response is, first, I think that the horse is well out of the barn. I'm not sure what the what the right analogy is, but the change is coming. The change is here. And we've seen so many other industries that have been disrupted by innovative business models. And I think, there's a couple of ways we can react to that. We can do nothing, which I really think is what will ultimately be harmful for the profession and potentially the public. Or we can try to be a part of it. One piece of feedback that I often get, and I wrote a column in our magazine about this a few months back, is people often wonder, well, if these kinds of legal services are like a gray area or perhaps not authorized under our current rules, why don't you just shut it down? Like, that's what I want the bar to do, just shut it down. And I think the piece that people don't understand is that the bar can only regulate those that we regulate. We don't have a police force. We can't go out there and just shut down people or tell people what to do. We only have authority over those that we regulate. So the best way that we can protect the public and ensure the health of our profession is to bring folks into the sphere of regulation. And there we can put in safeguards, we can monitor, and we can discipline if necessary.
With this pilot program, Washington becomes the third state to significantly loosen restrictions on the practice of law by non-lawyer entities. In authorizing this pilot, the Washington Supreme Court expressly cited its potential for enhancing access to justice. But how can a pilot such as this provide greater access to justice? What is the argument for loosening these restrictions? When we return, I'll ask my guests about that, but first, please take a moment to learn about the sponsors who so generously support this podcast. If you're a specialized law firm, your practice deserves more than a one-size-fits-all software. Case is tailor-made for workers' compensation, employment and labor, and insurance defense firms who demand precision. Imagine cutting through administrative chaos with intelligent document management, laser-focused time tracking, and seamless billing. Case isn't just software, it's your firm's competitive edge. Transform how you practice law at miruscase.com. That's MERUSCASE.com. We're talking today about a pilot program recently authorized by the Washington Supreme Court to license non-lawyer entities to deliver legal services in that state. My guests are two of the people who helped bring that proposal to the court and who will now be responsible for implementing it. They are Tara Nevitt, Executive Director of the Washington State Bar Association, and Craig Schenk, a board member of the Washington Supreme Court's Practice of Law Board, and also a practicing lawyer in Washington State. Let's get back to that conversation. There are probably some listeners right now on this program who are asking the question of how loosening some of the restrictions contained in Rule 5.4 or other restrictions on the practice of law can have an impact on access to justice. So what is the argument for how this kind of a pilot, or what's been done in Utah, as you talked about earlier, how entity regulation can have an impact on access to justice?
Craig, you want to take
it? Sure, I'll go ahead and dive in. Look, I think it's early days for us, but it's somewhat later days for Utah, where you can start to see some of that experience and how that has played out. And I think there are some really important factors to have a look at in there. One is, I do not anticipate that any of these projects that comes into Washington is likely to generate the full-blown robot lawyer who is going to go into court and represent an individual. However, they are likely to come up with innovative solutions similar to what we've seen in Utah that can help take some possibly repeatable processes and streamline and make them very low cost and much more broadly available. And I think, for example, about the Timpanogos Legal Service in Utah that has trained community advocates to be able to serve as direct advisors and advocates for people who have been in abusive relationships and who need protective orders. Now, obtaining a protective order is one of the most important roles that counsel and the justice system can provide, but it is often not a complex legal process. It requires an understanding of these repeated uses of forms. It requires a gentle and, frankly, a gentle hand with clients and a firm hand within the courts And getting those things together doesn't mean you need a law degree for each individual instance. You need somebody to supervise. But so they've actually enabled folks who are certified community justice providers to be able to go directly into court as advocates in those circumstances. There are several other examples of that around record expungement, around advocacy for medical debt that I've been very impressed by, and I think they represent the kind of things that we will anticipate seeing. And each of those provides an incremental aid in the access to legal services or the access to justice. These are services that are literally reaching people who would not otherwise be served.
If I could just add,
Please.
one of our organizational areas of focus right now is technology. So part of that is looking at how we regulate the practice of law as aided by technology. But the other piece of it is, how do we prepare the legal profession to both understand the risks inherent in technology and especially technology that they may not understand, but also the benefits? And I just want to believe there's such a tremendous opportunity here for legal professionals. I think the most recent Justice Gap study said that 92% of low income people don't get help for their legal problems. Although I don't have the numbers off the top of my head, I know that that's not just for low income folks. Lots of people do not seek legal help when they could or they should. They believe they can't afford it. They may not know they have a legal problem. There's a tremendous market for legal professionals to tap into. And I think that technology could really help them with that and really allow, one of my mentors and predecessors used to always say, lawyers should be practicing at the top of their license. They don't need to be the one drafting the form, but they can be the one sort of orchestrating everything. So I just really do think there's a lot of opportunity there for lawyers who would like to access that group of consumers that currently are not really accessing the help of lawyers.
It's probably important to also take into account that this pilot, or again the Utah program, is not to the exclusion of lawyers. And in fact, lawyers can be involved in these pilot entities. And I think the evidence out of Utah, at least documented by a study done by Stanford a couple of years ago now, I think, showed that in fact lawyers were very heavily involved in creating a lot of these entities. So this is not slamming the door on lawyers. It's perhaps a new opportunity, right?
Indeed, a new opportunity for both impact and scale. In addition to reaching a new group of potential clients who need the services.
Terry, you alluded to this earlier, but the applicants to participate in the pilot will have to propose, the wording is a specific hypothesis regarding kind of the regulatory rules that they want to reform and what the impact of that reform will be. I found that wording a little awkward when I read it in the court's order. But I mean, essentially, are you saying that they would have to come forward and say, look, 5.4 or whatever it is inhibiting our ability to do this. If we do this, it will have this impact, and therefore we think we should be licensed. Is that kind of what that's all about?
Yeah, pretty much. I mean, it's interesting. To speak to the awkward wording, I think, one of the pieces of feedback that we got was, there was some concern that folks thought, man, this is really vague. You're not giving me a lot of specifics. Like, what does entity regulation mean? Can you give me some specifics? What are we talking about? The truth is that it was rather intentionally vague, because part of what we're doing, in addition to testing entity regulation, we're also really implementing a framework through which to view innovation, and a framework in which we can safely explore innovative models and collect data and make sure that we're doing our job as the regulator, whose chief job is to protect the public. So because this framework can be used for a lot of innovations, and I think we just didn't want to stifle the creativity. There may be folks out there who can think of things we couldn't possibly imagine, and so we are intentionally leaving the ideas part vague. You bring us your ideas. The part that's not vague is how we're going to monitor and ensure that it's a safe pilot and that consumers are protected.
I might supplement that, Tara. We are indeed not going to be vague about our monitoring process.
Yes.
At the same time, one of the responsibilities of an applicant will be not just to give us their hypothesis and what about the area that needs to change and what will change as a consequence, but also help us understand how they would propose to measure it. One of the really difficult things in evaluating legal services at all is trying to get behind the curtain enough to be able to measure something. And so we're going to need help from the applicants. We will do our own measurement, consumer protection attributes that are visible, complaints, as an example. We will do our own work to ensure that that complaint process is highly visible to potential clients. But we also want to know, what do the applicants propose as a measurement system? How are they going to prove? How would they prove to their investors this is working? We are investing a whole lot of our good faith and credit in making this successful. So that's part of what we will look for from the applicants.
Yeah. Can you talk a little bit more about what it is that you're going to be looking to measure? Because I know, again, a key emphasis in the Supreme Court's order was this aspect of collecting data and information about these entities, about the pilot overall. So and again, I realize you haven't even started day one of putting this into operation yet, but I'm sure you've had some thoughts about what it is you're going to want to measure and monitor as you go forward.
Tara, I'll go ahead and jump in with a start, but I know you've given this a lot of thought as well. I think we will look to, right out of the gate, evaluating. So, as you said, Bob, we're in the process of building this, but things that we are imagining building will look to measurement of baseline things like client engagements, cost, reach, impact, and so on. Part of that is intended to understand, did we actually increase the reach of these services? Did we improve the cost foundations for these services? We are also going to try to find some ways to evaluate within that, is the impact of the service occur, the intended impact occur. That's a getting behind the curtain problem that we're going to have to do a little more looking at. We do have the ability to monitor, as I said, complaints. And we will pay attention to complaints. We'll pay attention to public comment and ratings and so forth like that. That would be the grounding point, I think. And then we have now a couple of months of hard work to build a monitoring framework, to build the structures in order to do that, to get the volunteer systems in place to do that, and get the data systems in place to do that.
Do you have a target date that you want to get this launched by?
Our target date is to build a target date within the next couple of weeks. we're in the plan for a plan stage, and that will proceed swiftly. But we got to get through that. We were delighted with your invitation to come talk, but we were cognizant that we don't have all the answers yet.
Mm-hmm.
Yeah. No, I understand that.
We'll never have all the answers, but
yeah, right. Yeah, when you have all the answers, let me know.
Yeah.
Tara, just on that data collection or information collection, do you have anything to add to what Craig was just saying?
Not really. I think that's right. And also, the order also specifically indicates that we need to be collecting data with respect to compliance with the authorizing order that the court puts forward, and making sure that they're adhering to the rules of ethics. One thing that I also think is important to emphasize is that each entity will be testing a particular regulatory rule, but every other regulatory rule, every other rule of ethics, every other state law, they must be in compliance with. And so we're also going to want to be monitoring that.
Yeah. I know, again, you mentioned that there will be safeguards, guardrails of sorts put in place. One is that the entities will have to have a compliance officer, which I think is similar to Arizona and Utah. Both have a requirement along those lines. And then there will be some sort of a public complaint and investigation and review process as well. Is that right?
Yeah. Yes.
So if members of the public are not happy or feel that they've in some way been wronged by one of these entities, they'll be able to bring in and bring a complaint and have that reviewed by somebody.
Yeah. And when we were first exploring this, it was daunting, I think, especially from the regulatory perspective, thinking about, we've been regulating individuals only since our existence. And it was a real, there were some mental blocks about how are we going to shift to regulating an entity. And I think what was a bit of a breakthrough was when we tried to just take a step back and say, let's not overcomplicate it. We know how to regulate individuals. We know how to figure out what competency looks like. We know how to do background checks, and we know how to respond when there's a complaint. And so, really, we tried to just sort of, as much as possible, apply that same expertise and processes and experience and knowledge to the regulation of entities. And so, I think that that'll sort of be my guiding star, is just to keep applying what we already know how to do very well, but just in this different context.
Was that don't overcomplicate it a lesson that you learned from the Triple LT program? I mean, I'd always heard that what part of the reason that shut down was because it was just kind of overcomplicated.
We learned a lot of lessons from the Triple LT program. And, I mean, and I couldn't agree more with what Craig said earlier. It is very difficult to go first. And I think that is one of the challenges of our state by state approach to the regulation of the practice of law in innovation, is that somebody has to go first and they have to take it all on. And I think, yes, I think that lessons learned, I think that Triple T program was probably overcomplicated, but I understand why, because we were the first. We had to really demonstrate that it was going to be safe and all the things. We had to respond to all the concerns. The other challenge is the cost. It takes a very long time to be the first one. We had to make up everything from scratch. And so, yeah, I was definitely approaching this with an eye towards, how do we not overcomplicate it? How do we do it swiftly? And how do we take advantage of the fact that this time we're not the first? So let's learn what we can. Let's steal what we can. Let's benefit from being a close follower.
Yeah, and by not being first, I mean, you mentioned again several times the Utah program. I think that Arizona is kind of off in a slightly different direction. But are there lessons that you took away from the Utah experience that you applied in crafting this proposal to the court here?
Bob, I think the lessons were more in the subtlety across the board. And frankly, one of them was that the Bar Association is a critical stakeholder and has a lot to offer. And Utah's new proposal came on very swiftly in 2020 that created a little friction in the system. And I feel like we have been talking about this within the state of Washington for several years. Really, this is now that we're 4 years into drafting orders and conversations with the court and the bar. That support it's helpful in that intangible way, but they've also given us very specific, clear support in terms of feedback that says things like, let's recognize the cost of this over time, even if we haven't fully scoped the numbers. We have a framing way of thinking about the money, even if we don't know how much this is going to cost yet. And we have a way of tuning that and a way of making sure that it does not break the bank on any front. We've also really focused on conversations about how do we advise and staff this group. And I feel like we've learned a lot, both in watching Utah, that now has a well-developed advisory board, but it took them a while to be able to get that into place. And so those are some things that I would take away as key lessons.
Utah described its program as a sandbox. I think I read somewhere that you deliberately avoided that term. Is that right?
Yes, well, that's feedback you get from the court sometimes helps. That's,
Yeah.
we'll take feedback from all quarters, and we got that. We got some feedback saying that it'll help move this through the system if we can be clear about what it is and try to avoid the jargon. And it is a pilot, and a sandbox felt jargony to some. Okay, that's valuable feedback. Let's not use the jargon.
Terry, you said earlier that horses out of the barn, I think was the expression you used in some respect regarding these issues. There were certainly back in 2020, after Arizona and Utah made their changes, there were some who were saying that the dominoes were going to start falling on a state by state basis, and clearly that hasn't happened since then. In a lot of ways, this is the first kind of major domino. I mean, there's been other reforms since then in other states, but this is one of the first big dominoes to fall. I'm curious if you're now hearing from other states about their interest in what you've done, or what your sense is of how this might impact other states thinking about similar reforms.
Yeah. This is one of a handful of reforms that we're working on. Another big innovation that we're working on is alternative pathways to licensure besides just the bar exam. And in this case, we're fast following Oregon, again, learning our lesson that we don't always have to go first. And I've gotten more interest in that. I don't want to pretend that I have, my finger on the pulse, but my sense is that people are still approaching this with a lot of trepidation.
Mm-hmm.
And to me, that mirrors our own trepidation and our just it's one thing to think about different ways of licensing individuals, but to think about moving beyond licensing individuals, it really is a big shift. And so, I haven't, just me personally, Craig may have a different experience, but I haven't heard quite as much interest in this as I have in some of the other things we're working on.
I might supplement that with, so we've seen explicit interest from Minnesota and Indiana over the last several months in similar kinds of projects. We've seen an explicit pullback in North Carolina and I believe in Texas from doing anything direct anytime soon. The ABA has indicated somewhat of a distinct lack of enthusiasm on the topic. The American Association of Professional Responsibility Lawyers just came out with a very thoughtful paper on why this should be done. And it's a helpful reminder that none of us anywhere on this continent is first. This has been in place in England, Wales, Australia, across the entire common law system for a long time. So it turns out that the sun does rise the next day when you allow for different versions of Rule 5.4.
Yeah, and as that April report said, the sky has not fallen yet in those,
Yes.
in those jurisdictions. But I'm sure there's a lot of lawyers looking up, wondering when that's going to happen. Well, we're just about at the end of the time. Is there anything else kind of that jumped out at you about either the court's order or that you wanted to point out about the pilot that you're going to be embarking on here that we haven't talked about?
I'll share a couple of things. I lost my father just a couple of years ago, but he was 91 years old when he retired from his practice of law. And it was just about then that I was able to start talking with him about this. And he was tremendously enthusiastic that we were going to try something. He recognized that doesn't mean that what we start with will be the end point, but that we'll try something. And he reminded me again and again and again that lawyering is not just a learned profession. It needs to be a learning profession. And we got to learn, not just individually, but together. How do we handle this coming new world?
A wise
Well
man.
said.
Yeah. Tara, anything else?
No, I don't think I have anything to add. I can't beat that. That was great final words.
All right. Well, I will certainly stay tuned and maybe after this whole thing gets up and running and had a little time under your belts, we can get you back on here and talk about how it's going and what progress you've seen. I think this is a really exciting move, and congratulations to both of you and your organizations and the roles you've played in making this happen.
Thank you, Bob. We have a lot of learning in the next few months, and we'd love to come back and share what we've learned.
Absolutely. Thank you.
That sounds great. All right. Well, thanks so much for your time, and happy holidays to you all.
Thank you. You as well.
Likewise.
Thanks for listening to today's show. I hope you enjoyed it. If you'd like to share your own thoughts or comments on this issue or anything else, please do so by messaging us on LinkedIn or X, or you can find me on Blue Sky as well, or just email me directly, ambrogi@gmail.com. If you're a fan of the show, please leave us a review wherever you get your podcasts. LawNext is a production of LawNext Media. I'm your host, Bob Ambrogi. I hope you'll join us again next time for another episode of LawNext.